And what do you think? Do we have enough for a quorum here?
Brandon, I saw your lips moving. I didn't hear anything. Is everyone else hearing Brandon? Is it just me?
Yeah.
Wait, so you can or cannot hear me?
I can hear you, Brandon. Yes.
Hear you, yeah.
Okay. It's just Dag. All right, Lisa, can you please take roll?
Absolutely.
I'll call the Regulation and Discipline Committee meeting to order, and Lisa Chavez, if you could please take roll.
Okay. Broughton.
Here. Excuse me,
Chen?
here.
Okay. Chen. Cisneros.
Here.
De la Cruz.
Here.
Duran. Sorry. Okay. Wait, it's Duran. Ruben Duran?
Here. I'm here.
Okay, good. Ganong.
Here.
Pertula.
Here.
Saleg.
Here.
Sowell.
Present.
And Stalling.
Present.
Okay, terrific.
All right, looks like we have a quorum, and I will open this meeting up with a call for public comment. And are there any members of the public who wish to address the Regulation and Discipline Committee and any of the agenda items set forth today? And if so, please raise your hand, and then I'll have staff promote you the appropriate time. And I would ask that you limit your comments to 3 minutes to the length of today's agenda. All right, staff, do we have anybody wishing to make public comment? Lisa or Dag, anybody? Okay, seeing as no members wish to make public comment, there is going to be a change on the agenda. So the closed session will be moved to the end of the agenda, and that is the Rule of Procedure 2201 case updates. So just to let everybody know that will be taking place in approximately, I'm going to say 40 minutes or so. Moving on to the chair report. Happy New Year officially to everyone. I trust that everyone had a wonderful time over the holidays and that you're ready for another action-packed year with the Regulation and Discipline Committee. I want to welcome the new members of the board and look forward to working with both of you on RAD and the full board agenda items. I will try and would encourage everybody on RAD to not speak in the alphabet soup terminology, as the amount of bar entities and their abbreviations is voluminous. So if anybody has any questions about a acronym that's thrown out, please don't hesitate to stop us if you don't know what that relates to. So your RAD chair, myself, and Vice Chair Highland Chin have been working with staff to implement reforms consistent with board directives and are continuing to study potential reforms and look at effective ways to improve our discipline system, all while looking at the principles of equity, inclusion, and implicit bias. Thanks to the work of the Office of Research and Accountability, Melanie and Steve, we are happy to announce that we have completed the technological machinations to implement the prior complaint screening consistent with the direction of the board and the recommendation of Professor Robertson. This is to ensure that complaints are considered on the strength of each individual case while maintaining the balance of ensuring that repeat offenders are fairly identified and litigated in a judicious way. We are excited about continuing our work in groundbreaking areas of proactive programs with the goal of decreasing the amount of individuals in California who are harmed by lawyers and making sure that lawyers receive the appropriate level of education and instruction to prevent harm to the public and ensure the highest level of professionalism that the public expects from our licensees. A majority of our time, past couple months, has been spent with staff in your strategic planning session. So this is a public protection agency, and so rightly so, the emphasis this year has been put on our discipline system and ways to improve what we do. I would like to give a huge shout out to staff who put in incredible amounts of time in planning this. And just to name a few, Donna Hershkowitz, Melanie Lawrence, Steve Moad, Lisa Chavez, Ron P., and the tireless Dag McLeod, who has devoted substantial amounts of time to refine our agenda and bring these important issues before this board. So thank each and every one of you for your work and for your innovative approaches. Just a quick update on the civility project. The project continues full steam ahead, with Justice Brian Curry chairing this working group. We've added a co-vice chair, Heather Rosing. Some of you may recognize her as a former member of the Board of Trustees and also as the first president of the California Lawyers Association. So between the three of us, we are taking on 3 areas of potential action involving the enforcement of potential civility rules, requiring lawyers to take the civility oath on an annual basis, and having a minimum amount of reportable civility education. This is one of the first endeavors where the State Bar and CLA are working together on an important statewide initiative to increase the public's trust in the professionalism of our licensees. One of the main agenda items on today's agenda is a judicial complaint policy, and it is the culmination of a lot of hard work on the part of State Bar Court, former Chair Alan Steinbrecher, Sean Saleg, and members of RAD. So look forward to the rest of the agenda. That is my report. I'll move on to consent 2A. There's only one item. Does any member wish to have this pulled off of consent? I would note that this was put out for public comment in September for a 60-day public comment period. There were no public comments received, and it was deemed that this should go on consent. Anybody wish to pull it off? Okay, I think I just need a second and then take a vote.
This is Jose, I'll second.
All right, second by Jose. Lisa, please take the roll. Oh, you're on mute.
Yes.
Let me start over. Broughton?
Yes.
Yes, okay. Chen? Cisneros?
Aye.
De La Cruz?
Yes.
Duran?
Yes.
Ganag? Ganag?
Ganong, yes.
Ganong, yes, thank you.
I'm going to announce a vote. Is it too disturbing for you for me to do this?
Pertula?
Yes.
Saleg?
Yes. Oh,
So-
sorry, abstain.
Okay. Saleg abstain?
Yes, I abstain on this item. Thank
Okay.
you.
Sol?
Yes.
It passes.
All right. Going on to business 3A, which is the proposed procedures for responding to complaints against State Bar Court judges. Presenting on this item has been involved in the really working on this for the past couple of years. And like I said on my chair report, this really builds off of a work that Alan Steinbrecher and Sean Saleg started a couple of years ago. And so just briefly, kind of bullet point wise, this item would establish an internal administrative framework for investigation of allegations against State Bar Court judges that could result in liability for the State Bar. So this policy follows an extensive and careful internal deliberation and consultation process between RAD and State Bar Court over a 2-year period. The proposed policy we feel appropriately balances the independence of the State Bar Court judges with the State Bar's need to manage its legal risks. And I think what is really important, because this has come up in a significant amount of our conversations with State Bar Court, that this policy does not purport to exert any authority to discipline a State Bar Court judge. So the board, however, does have administrative authority over the State Bar Court and over the judges to the extent that they are employees of the State Bar for purposes of indemnification and representation under the Government Claims Act. So the board respects and understands that only the California Supreme Court has the authority to discipline or retire a State Bar Court judge following an investigation by the Commission on Judicial Performance on behalf of the Supreme Court pursuant to Rule 9.11, subsection D of the rules of court. Some things that the board really, at least members of RAD who worked on this, really had in mind in formulating of the rule as our commitment to ensuring fairness in the process, including by allowing judges the full opportunity to participate in any investigations conducted under this rule, and by maintaining the confidentiality of those personnel matters to the extent possible. So under this internal policy, complaints regarding state bar court judges shall be sent to the executive director for a determination of whether they state allegations that, if true, could create liability for the state bar. If the executive director determines that the allegations could create liability for the state bar, she will report them to the RAD chair, who will conduct an independent investigation and recommend appropriate remedial actions within the state bar's administrative authority. So these recommendations may include, for example, reassigning effective support staff or early resolution of potential legal claims against the bar. So during our engagement with State Bar Court, there have been some issues raised by the court that I told them I would bring to RAD, just so you could be fully informed as to the discussion between RAD leadership and then State Bar Court leadership. There was a concern that this would place an obligation upon State Bar Court judges to determine liability potential on all allegations, including any sort of disqualification motions, complaints from the public, complaints by litigants, or complaints by counsel. And I think what is important to note is that this policy, because it's a blanket policy that requires all complaints to be sent to the executive director, it really removes discretion that someone could point to and say that further misconduct happened because a complaint was not forwarded to the appropriate individuals. State Bar Court currently already forwards complaints to the Committee of Judicial Performance, and then also anything relating to anything related to personnel, they do relay on to HR. What this policy does is ensure that the executive director of the State Bar receives all of those complaints and is able to then determine if any state liability could occur and then take appropriate actions from an investigation standpoint. Second large concern was the California Public Records Act and whether or not the investigations would be subject to CPRA disclosure. State Bar would work within the confines of the law and and uphold the confidentiality of any personnel records, knowing that they're generally exempt from such disclosure under CPRA. And then third, a concern about any sort of necessary remedial actions and concerns that this could result in the disciplining of a judge. And again, I would note that final authority to discipline a State Bar Court judge rests with the Supreme Court, and we do not seek to get in the way of that. The necessary remedial actions we're taking are acting within our authority, such as transferring support staff members who might be impacted by potential misconduct. That is, in a nutshell, what this rule purports to do. I would just open it up for any questions, comments, concerns. All right, I see Mr. Mark Broughton.
It is I, Chair. I'm just wondering at the end, at sort of the last point there, should general counsel be brought in so that you can consult with general counsel? And then my question is, do you let's say there is an issue and you decide that it should be, not you personally, but I mean, we decide that it requires some action. Would it be, is that recommended to the Supreme Court then, and the Supreme Court takes the action? Or do we actually do that either as RAD or the board?
I see Vanessa raising her hand.
Hi, Mark. Taking your questions in order. The first one is, when these matters are reported to the executive director or to RAD, Office of General Counsel is their counsel, so they are available and could be involved in what response is taken. And similarly, we have offered to the State Bar Court in their own handling of this or other matters that we could assist them also. Wait, what was the second question? Oh, recommendations. So what's important about this rule is that the State Bar does not have, although the State Bar judges are statutory officers and employees of the State Bar, and the State Bar, represents and indemnifies them in lawsuits and all that, and that's why we have this rule. Under the rule of court 9.11D, the State Bar does not have any disciplinary or retirement authority over the judges. So we would not be recommending or having a role in that. All we could do, if it were a matter that could create liability for the State Bar, is to take care of matters around that. So for example, I'm thinking of a civil court judge in the last year who went through a long trial for sexual harassment. It was found that he had engaged in it. If a meritorious claim were made against a State Bar Court judge, no expectation there will be or has been, we could talk to the alleged victim or the actual victim about transferring them. I mean, it gets tricky because normally you have the authority to take the action against the perpetrator, but we do not have that here. That's the distinction. Only the Supreme Court does. That doesn't mean that we couldn't advise the Supreme Court of the situation, but it would be working with the Commission on Judicial Performance, which is its investigative arm. It's a whole separate process to come to its own conclusions. We could share information or answer any questions they have. We could also decide that if we had a lawsuit by the victim, that we might, need to settle that early on because of the liability, that sort of thing. It's a little different than all our other employees because we do not have disciplinary authority over State Bar Court judges. Does that answer your question?
I guess I'm not really sure what we do here, but I'll take it as is. I've not heard that there have been any such complaints. Have there been against judges?
Yes. Oh, I've only been here for 5 years. I think there's been about a half dozen. And that doesn't mean that they're meritorious. People don't like decisions or employees don't like the way their supervisors are treating them. So they file claims, but they still have to be processed. And all it takes is one big meritorious one, and the State Bar could have high liability.
And again, what this seeks to do is promote confidence in our internal processes and make sure that any sort of claim, whether meritorious or not, is reviewed and is given its day in court, so to speak.
Mr. Chair, I see a question from Trustee De La Cruz.
Yes, Mr. De La Cruz.
Yeah, thank you, Donna. I think Vanessa answered a lot of the questions that I had, but I have a couple of questions. One, for my knowledge, how many State Bar judges do we have?
I've lost count because we just added a few. Someone else knows the answer to that better than I.
I think it's 7, 5 hearing judges.
It's 8, 5 hearing and 3 review.
And the other question I have is, Vanessa, you made an example of sexual harassment, but what merits a claim? What merits an accusation towards a judge? Is it solely, for example, you mentioned that it was sexual harassment, but does a decision by a judge also merit some complaint by someone, or is that separate and apart?
Well, anyone can file any complaint, right? I think you're asking what is a meritorious or what is the kind of complaint that would fall under this rule. So, I can't give an exhaustive list, but the criterion is that which could create liability for the State Bar Court judge employer, the State Bar, that we need to fulfill our duties to investigate, reach a conclusion, and take remedial action, expeditious remedial action. So some examples that come to mind are discrimination claims, either harassment or just regular discrimination in promotion or hiring or something like that. An employer has obligations to immediately investigate, to reach a conclusion, to take appropriate remedial action, and failure to do so can cost a pretty penny in front of a jury. So that would be an example. Another one might be a whistleblower claim that, some illegal government activity is going on at the bar, at the state bar court. And so we need to be able to look into that. Or a tort claim, assault, battery, intentional infliction, slip and fall, those kinds of things that we would have liability for. It isn't that someone doesn't like the decision of the judge, someone doesn't like how long it took, or even just made up things. We would look at them and determine if they have merit, and we will treat them accordingly.
Got it. Thank you.
Any other questions?
Brandon, is there a staff recommendation that we can see up on the screen, or is it simply direction?
So there is.
It's a resolution, a draft
Yes.
resolution that, is Dag doing this, or Lisa?
This isn't a consent item, correct?
No, it's not.
No. And this is going to go to the full board. If it passes out of RAD, it'll go to the full board, and we will have a further discussion there as well. You can see it there, resolved that the Board of Trustees amend the rules and regulations of the State Bar of California pertaining to the benefits, terms, and conditions governing State Bar Court Judge service, Section 23, as set forth in Attachment A to this item. That is the resolution. For a second.
I'll move it if somebody didn't.
I'll second it.
I'm sorry. I think that was Mark first. Second.
Juan.
Yep.
Then Juan second. All right. Any further discussion? All right. Seeing none, Lisa, please take the roll.
I can't hear her, but I'm assuming I'm first. Yes.
Excuse me. Broughton,
Yes.
Chen, Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Yes.
Ganong,
Yes.
Pertula,
Yes.
Dole.
Yes.
Passes.
All right.
Thank you.
Thank you very much. Moving on to business 3B. This is update on metrics for offices within Regulation and Discipline Committee purview and discipline system statistical report. And that is going to be delivered to us by Lisa Chavez.
Hi, everyone. I'm in the interest of moving this meeting along. I'm just going to give you an overview of this agenda item. It's really just an informational item that's going to be discussed in more depth at tomorrow's meeting under agenda item 706. It has to do with the fact that we recently reviewed all metrics bar-wide that we are tracking for 2021. And the purpose of this agenda item is just to call your attention to the metrics, the 30 plus metrics that are under the offices that are under RAD's purview. That's the Office of Chief Trial Counsel, State Bar Court, Office of Professional Competence, Probation's Client Security Fund, and Lawyer Assistance Program. And so, so the agenda item just summarizes the changes that we made. Like I said, tomorrow we'll be discussing the review and why we undertook it and the different changes we made more in depth. So I'd prefer to push that discussion to tomorrow, if that's okay. And the only other thing I'll just want to describe is the discipline statistical report, which is attached to this item as well. This is just a report that we produce every 2 months and distribute via this agenda item. I think when we produce our next metrics report in March, that will be the time when, and we'll also do the DSSR, that will be a good time during my presentation to really show how these two reports complement each other.
All right, so does anybody wish to have an in-depth discussion on this right now, or are we okay essentially moving it on to tomorrow's discussion?
Tomorrow.
All right, seeing no strong objections, we'll move on to item 3C, which is discussion and adoption of 2021 Regulation and Discipline Committee work plan. As this is a outgrowth of last board meeting's meetings or last RAD meetings discussion of our work plan. There is a updated work plan there on the agenda item. Are there any questions by any of the committee members on any of the items? Does anybody recall us putting anything on that's not on this current work plan, or any questions about the timing or why something's on the agenda? Okay, doesn't look like there's any questions. Can I have a motion to, let's see, the resolution? Can we put the resolution up on the screen, Lisa?
Yes.
Resolve that the Regulation and Discipline Committee adopt the 2021 Regulation and Discipline Committee Work Plan. Included with this item is attachment A, subject to approval by the Board Executive Committee. So as to that resolution, do I?
Brandon, this is Jose. This is Duran. I'll move that. I'll second it then.
Okay, first by Jose, second by Ruben. Any further discussion? All right, seeing none, Lisa, please take the roll.
Okay. Broughton,
Yes.
Chen, Ciceros,
Aye.
De La Cruz, Duran, Duran,
Yes.
Ganong,
Yes.
Pertula,
Yes.
Dole,
Yes.
and Saleh. Okay, thank you. It passes.
All right, excellent. All right, we are going to be closing the open session of the RAD meeting. We're going to be going into closed session. Each member of the committee should have received a link to the closed session. So when we, if you could shut this meeting down, go into that. This is going to be closed pursuant to Government Code Section 11126 sub C sub 2. I would anticipate we'll come back in about 10 minutes, pretty close in time to the estimated start time of the executive committee meeting. So we'll adjourn closed.
Mr. Chair, if I could ask, from whom did the email come with the link to the closed session?
It came from me, Ruben. And I got
Okay, I'll search for that.
Okay.
Thank you.
Okay, thank you.
All right. All right, we will see you all in closed. No action was taken in close. And with that, we'll adjourn the RAD meeting.